Welcome back to the deep dive. You know how sometimes you're faced with these incredibly dense legal documents, and you just wish someone could cut through it all and tell you what really matters?
Yeah, absolutely. It can be overwhelming.
Well, that's exactly what we're aiming for today. We're diving deep into South Africa's Companies Act, 2008. It's this really crucial piece of law that pretty much underpins every business you interact with.
It really does. It's fundamental.
So, whether you're thinking of starting a business, you're an investor, maybe just a curious citizen, or even a law student looking for some practical insight beyond the textbook, this deep dive is definitely for you.
Mm-hmm.
We're going to unpack its main purpose, walk through the really impactful parts, get the legal context, and, see how it plays out in the real world.
That sounds good.
Think of it like your shortcut to being genuinely clued in. We'll try and find some surprising bits, maybe a touch of humor to keep it interesting. So yeah, let's get started.
Let's do it.
Okay, so first things first. Before we get tangled in the details, what's the big picture? Why did South Africa even bring in this new Companies Act back in 2008? What was the main driver?
That's definitely the right place to start. The 2008 Act wasn't just a minor update. It was a complete overhaul. It replaced the much older 1973 Act.
Right, the really old one.
Exactly. And it even tweaked the Close Corporations Act from '84. The main goal, and it says this right in the preamble, was to create a more consistent and harmonious regime for how businesses are set up and regulated.
Okay, so like modernizing and simplifying?
Pretty much, yeah. Modernize, simplify, make it easier to actually start and run a business. But also, and this is key, ensuring fairness and transparency. It specifically wanted to boost entrepreneurship, make the economy more efficient, and importantly, align company law with the Bill of Rights. Plus, making it simpler to raise capital, spread risk. And it tries to balance the rights and duties of shareholders and directors, and even sets out rules for nonprofits. It was really about dragging South African corporate law into the 21st century.
That sounds like a pretty ambitious goal. So does this modern act apply the same way to every single type of company? Or are there different rules for different folks?
That's a great question. It's not entirely a one-size-fits-all approach. While it applies broadly, the Act does recognize that companies differ. Take state-owned companies, for example. Some provisions might apply differently if there's other specific legislation already covering them.
Makes sense.
And for nonprofits, certain rules, like the ones about shareholder meetings, they might only kick in if the nonprofit actually has members with voting rights. It shows a bit of flexibility, adapting the rules.
Interesting. Okay, so we've got the big vision, but let's bring it down to the ground level. Say I'm dreaming up a new business right now. What's the very first practical thing I need to get my head around from this act? What's the foundation?
Right. The absolute foundation is this concept of a juristic person.
Juristic person. Sounds a bit formal.
It does, but think of it like this. The moment your company is registered, the Act says it becomes its own legal person, separate from you, the founder.
Okay, like its own entity.
Exactly. It can own property, sign contracts, sue people, get sued. All separate from its owners. This idea of separate legal personality is, well, it's the bedrock. Everything else builds on that. And this separate legal life is largely defined by a document called the Memorandum of Incorporation, or the MOI.
The MOI, okay.
Think of the MOI as the company's constitution, its internal rulebook. What's quite neat is that the Act has what it calls alterable provisions. These are rules in the Act that your MOI can actually change, tweak, or even build upon.
So you can customize it.
Precisely. You can tailor how your company operates, within limits, of course. The MOI can even set higher standards than the Act's basic, unalterable rules. And the board can add its own rules, too, as long as they fit with the Act and the MOI. It's about fitting the legal structure to the business.
That flexibility sounds really powerful. But, okay, before you even have an MOI or this juristic person, you need to actually create it. What about those very first steps, naming it, registering it? That feels like where the initial hurdles might be.
Absolutely. It starts with the name. The Act is clear here. The name can't be the same as another registered company or entity. And it has to end correctly, like PDLTD for a private company or NPC for a nonprofit.
Got it.
You can reserve a name in advance, which is handy. The actual setting up the incorporation, it's fairly streamlined now. You file a document called a Notice of Incorporation, along with your MOI, with the CIPC, that's the company's Intellectual Property Commission. They're the official registrar.
CIPC, right.
And here's something really useful for entrepreneurs who are eager to get going. Pre-incorporation contract.
Pre-incorporation. So before the company officially exists.
Exactly. Imagine you found the perfect office space, maybe bought some equipment, signed deals. But the company isn't technically registered yet. Section 21 of the Act lets the company, once it is registered, formally adopt or ratify those contracts made on its behalf beforehand.
Oh, that's super practical. Saves a lot of hassle later, I bet.
It really does. But the Act isn't just about making things easy. It also has rules against operating recklessly or trying to defraud creditors or shareholders.
Yeah.
If a company does that, the CIPC can investigate and could even apply to have the company shut down or wound up.
Right, you need those safeguards. Okay, so that's setting up. But thinking longer term, what about financial transparency? How much does this act require companies to reveal about their inner workings, and why is that such a focus?
Yeah, transparency and accountability are major themes. Companies have to keep pretty extensive records, founding documents, meeting minutes, detailed accounting records, financial statements, and they need to keep them for 7 years.
7 years,
Yeah.
okay.
And the why is crucial. It allows shareholders, and sometimes the public, to actually see what's going on inside. Shareholders have specific rights to inspect key documents like the MOI, the share register, meeting minutes, annual financial statements. It's about building trust, you know?
An open book policy, essentially.
In many ways, yes. And those financial statements, they have to meet prescribed standards, give a fair picture of the company's health, and say clearly if they've been audited or just independently reviewed. Lying in those statements is a serious offense.
And who needs an audit? Is it everyone?
Public companies must have their annual financials audited. For other companies, it depends on regulations or their public interest score, basically how much impact they have. And interestingly, there are these uncommenced amendments, parts of the act written but not yet activated. For public and state-owned companies, these future rules will force them to prepare reports on how much they pay executives and get shareholder approval for their pay policies. A big step for transparency there.
Executive pay, always a hot topic.
Definitely. And every company has to file an annual return with the CIPC. Again, looking ahead, future changes might require including a register of beneficial interest, showing who really owns the company.
Okay, that's a ton of important info. Let's shift focus slightly to ownership itself. What's significant in the act about how shares are structured or how ownership is tracked? This feels really relevant for investors.
Very relevant. Shares are basically slices of ownership. The MOI has to spell out what kinds of shares the company can issue, how many, and what rights come with them, like voting rights, rights to dividends, what happens if the company dissolves.
So the MOI is key for shares, too.
Absolutely. One thing you can't take away, though, is the right for shareholders to vote on changes to the MOI itself. That's an irrevocable right. The board issues shares, but only within the limits set by the MOI. Issuing shares they aren't authorized to. That's void, and the money has to be returned.
Makes sense. Protects the structure.
And the Act is quite strict about companies providing financial help, like loans or guarantees for buying their own shares or giving loans to directors. It's not banned, but it requires passing a tough solvency and liquidity test.
Solvency and liquidity, like a financial health check.
Exactly. Can the company pay its immediate debts, liquidity, and are its assets greater than its liabilities looking ahead? Solvency. Any distribution to shareholders, like paying dividends, also has to pass this test. The company can't just give away money if it jeopardizes its financial stability.
Right, protecting creditors, too.
Precisely. But maybe the biggest game changer for transparency, especially fighting things like money laundering, is this focus on beneficial ownership. This is a real nugget for listeners.
Beneficial ownership. Tell me more.
Okay, so you might have shares registered in the name of one company or person, but who really owns or controls those shares? Who's the actual individual benefiting? That's the beneficial owner. The Act requires disclosure of who these individuals are.
So peeling back the layers.
Exactly. And again, there's an uncommenced amendment here that says the CIPC will eventually maintain a public register of this beneficial ownership information. When that comes into force, it'll be a huge step for transparency. You'll be able to see who ultimately controls companies.
Wow, that is significant. So with all this structure and transparency, how does the Act actually empower shareholders in governing the company? Do they get more say now?
Oh, definitely. Shareholder power is significantly boosted. For instance, clear proxy rights. Shareholders can appoint someone else to go to meetings, speak for them, vote for them. Makes it much easier for investors, wherever they are, to have their voice heard.
So you don't have to physically be there.
Right. And if shareholders feel strongly about something, if a group holding just 10% of the voting rights wants a meeting on a specific issue, the board has to call one.
That's direct action.
It is.
Yeah.
And decisions at meetings happen through resolutions. You've got ordinary resolutions needing just over 50% vote for routine stuff. But for the big things, changing the MOI, Approving mergers, certain share issues, you need a special resolution.
And that needs.
At least 75% of the votes. So shareholders have real veto power or approval power over major fundamental company decisions.
Okay, we've covered birth, daily life, ownership. But company life isn't always straightforward, is it? What about big changes, like mergers or selling off huge assets? Or, on the flip side, when a company hits really rough financial waters?
That's where the Act provides frameworks for major shifts and, crucially, for rescue efforts. Let's take fundamental transactions first. Things like selling off most of the company's assets, merging with another company, or major restructuring schemes.
The really big strategic moves.
Exactly. These generally need that special resolution from shareholders we just talked about, signifying how important their buy-in is. And there's protection for those who disagree. If shareholders vote against certain fundamental deals, they have appraisal rights. This means they can basically say, okay, you're doing this deal I hate, so you need to buy my shares back from me at a fair price.
An escape route for unhappy minority shareholders.
A vital one. And then you have takeovers. The Act set up the Takeover Regulation Panel, or TRP. Their job is to oversee these deals, make sure shareholders are treated fairly, and stop companies from unfairly blocking legitimate offers. For instance, if someone buys up a certain percentage of shares, could be up to 35% in a regulated company, they might have to make a mandatory offer to buy out everyone else.
Ensuring fairness for all.
That's the goal. There's even a squeeze-out provision where if an offeror gets 90% of the shares, they can compel the remaining 10% to sell.
Okay, that covers big changes. Now, what about that rescue part? You mentioned that. Business rescue sounds like a major innovation compared to just letting companies fail.
It absolutely is. Business rescue, covered in Chapter 6, is one of the landmark features of the 2008 Act. The whole point is to try and rehabilitate companies that are financially distressed rather than just liquidating them straight away.
Financially distressed meaning?
The Act defines it as being reasonably unlikely to pay your debts within the next 6 months, or likely to become insolvent in that period. It's about intervening before total collapse.
Proactive, then.
Very. The aim is to save jobs, preserve economic value if possible. How it works is, a business rescue practitioner, an expert, is appointed to take control of the company's management. Crucially, there's a moratorium on legal claims. Creditors generally can't sue the company while it's in rescue. This gives breathing space. The practitioner can also look at existing contracts and suspend or even cancel ones that are dragging the company down.
Wow, that's quite a bit of power.
It is, but the goal is to develop a business rescue plan. This is the roadmap showing how the company will be restructured to become solvent again. And this plan needs approval from creditors, usually a majority in number, representing 75% of the debt value, and sometimes shareholders too. It's a collaborative rescue attempt.
A really different approach to corporate failure. Okay, so with all these rules, formation, governance, financials, rescue, how does the Act actually ensure people follow them? What are the teeth? The enforcement?
Right, rules are only good if they're enforced. The Act sets up a few key regulatory bodies. First and foremost is the CIPC, the Companies and Intellectual Property Commission. We mentioned them for registration. They're the main registrar, but they also promote compliance, handle complaints, investigate breaches, and keep those public records.
The main watchdog.
Kind of, yeah. Then there's the company's tribunal. Think of them as facilitators for dispute resolution, mediation, arbitration. They also review some CIPC decisions, like disputes over company names, and we already mentioned the Takeover Regulation Panel, TRP, specifically for overseeing those big takeover deals and offers, ensuring fairness.
Right.
Finally, there's the Financial Reporting Standards Council. They advise on accounting standards, making sure the financial reporting rules are robust and appropriate for South Africa, often adapting international standards.
Okay, so those are the official bodies. But what about individuals? If I see something wrong or I'm a shareholder being treated unfairly, what tools does the Act give me?
That's critical empowering individuals. The Act does provide some strong remedies. Take whistleblowers. Section 159 offers protection to employees or others who, in good faith, report misconduct like fraud or illegal activities within a company.
Protection how?
They're protected from retaliation, and they can even seek compensation if they suffer negative consequences, like losing their job, because they spoke out. It encourages people to flag wrongdoing.
That's important. What else?
A really powerful tool is the declaration of delinquency or probation for directors. This is serious. If a court finds a director guilty of gross abuse of their position, maybe gross negligence, intentionally harming the company, or repeated rule breaking,
Like a corporate naughty step.
More like being sent off the field entirely. They can be declared delinquent, which usually means they're banned from being a director of any company for a significant period, often 7 years or more. It can effectively end a director's career. And again, those uncommenced amendments suggest this area might get even tougher in future.
A major deterrent, hopefully.
That's the idea. Shareholders also have direct recourse if they feel the company's actions are oppressive or unfairly prejudicial to them. Section 163 allows them to go to court and ask for relief. And what if the company itself should be suing someone, say, a director who harmed it, but the board won't act? Shareholders can now bring derivative actions. With court permission, they can sue on behalf of the company, taking matters into their own hands legally. Precisely. And finally, for general compliance, the CIPC or the TRP can issue compliance notices. If a company ignores one of these notices ordering them to fix something, that's an offense in itself, and they can face hefty administrative fines, potentially up to 10% of their annual turnover, or R1 million. So there are real financial penalties too.
Wow. Okay, that was genuinely a deep dive. We've gone from the act's big vision and legal roots, right through setting up shop, managing money and shares, handling huge deals and rescues, and finally, the watchdogs and the ways individuals can hold companies accountable. It's clear this act really shapes almost every part of corporate life in South Africa.
It's incredibly comprehensive, yes.
And for you, our listener, we really hope this gives you that crucial context. Whether you're involved in business decisions, looking at investments, or studying law, understanding things like beneficial ownership, that key nugget for transparency, or how business rescue actually works. It's not just theory, it's really practical, essential knowledge. This law really sculpts the commercial landscape.
Absolutely. And maybe a final thought to chew on. If we think about all those uncommenced amendments, we mentioned the future rules on executive pay reporting, the public beneficial ownership register, maybe longer periods for delinquency applications. What does this constant evolution tell us?
Good question.
How does this built-in legislative foresight, this plan for future changes, actually shape the day-to-day reality of corporate governance and transparency in South Africa right now and going forward? It definitely means businesses, directors, legal professionals, they all have to stay alert, constantly adapting to a legal environment that's designed to keep evolving. It certainly keeps things dynamic.